I get asked all the time, what happens at a DMV hearing? And do I need to testify at a DMV hearing? So I want to take just a couple minutes to explain to you what happens at a DMV hearing and give you some more insight as to whether you need to testify or not testify. So the first thing to understand is that a DMV hearing is not criminal. You don't have constitutional rights. There's a much lower standard in the state of Nevada for a DMV. As a matter of fact, it's not even held in a courtroom. It's held at a DMV office, and it's held by a DMV hearings judge. So it's not the kind of judge you're thinking about. Second thing you need to know is that under Nevada law, the DMV hearing judge is encouraged to take away somebody's ability to drive. There's a public policy set from the Nevada Supreme Court that people's licenses are to be taken away from them if they were above the legal limit or if they refused to comply with the test. So let's talk about what's going to happen. Really, three things. Number one, can the officer prove that you were the driver? Number two, were you above whatever the legal limit is, whether that's for alcohol or for certain drugs, or if you had a prescription drug and you didn't have a prescription? And the third thing is whether you agreed or refused to take the test. So let's take those one at a time. So, were you driving? How do they prove that? Well, obviously, if the officer pulled you over for a traffic infraction, the officer is going to be able to testify that you, in fact, were the driver, and that's how the officer knows you were the driver. Sometimes the officer didn't see you drive. There was an accident, and the officer comes upon the accident and comes in contact with you, and you make an admission that you, in fact, were the driver. Well, for DMV purposes, you've now admitted to being the driver, and they can use that against you. A third way, and it gets really frustrating, is if somebody else told the officer that you were the driver. So there's an accident, you never said anything to a police officer, but the other person in the accident pointed you out and said, oh yes, that's who the driver was. Or if there was a witness there and they saw the accident and they point to the officer and say, yes, that's the driver. So the only time I'm going to have you come and testify at a hearing is if our defense is you were not the driver. Because if you were not the driver, then you can testify you were not the driver. Or if you have somebody who is with you and can explain that no, in fact, that person was driving and you were not the driver, then I'm going to want either you or that person to come and testify. So that's the first thing. Second thing is, were you at or above the legal limit? And again, we have legal limits for alcohol, certain drugs like marijuana and cocaine. They just have a level just like alcohol does, or a prescription drug. Now, the question is not whether at the time of driving were you above the limit. It's actually at the time of the test were you above the limit, which again gets very frustrating because sometimes the test will be taken 2-3 hours after the event, and our defense in court is going to be, well, at the time of driving you were not above the limit, but when they took your blood 3 hours later, well, at that point you were. Well, for DMV purposes it does not matter. For DMV purposes the question is, at the time of the test were you above the legal limit? This happens and gets very frustrating when somebody's gone home, they've had a couple drinks, we have proof they've had a couple of drinks, and the DMV still says, well, it's at the time of the test. So that can be very frustrating, but that's what the law is. And the final thing is whether this is a refusal. There are some cases where the officer claims that the officer told you under Nevada law that you must consent to do certain tests, whether a breath test or a blood test, and you said no, and the officer went and got a search warrant. The question there is, should you testify? And realistically, if the officer says that you refused, even if you come in and say, oh no, I didn't refuse, that's really not going to be a great defense. Where we have luck in those cases is, number one, sometimes I have the video of the event before we go to the DMV hearing, and I can see in the video the conversation between you and the officer, and I can see the officer did that wrong. Well, if I've got a video of the event, I'm going to play that at the DMV to show the judge, the hearing judge, that they didn't do it correctly. Sometimes the officer in his report doesn't mark things down correctly. So I can turn to the report and say, wait a second, you never put in your report that this person refused. And then I've had occasions where somebody has had a head injury. There's unfortunately been an accident, and we can show my client had a concussion and did not understand. Now, not every judge will use that as a defense, but some judges will. So essentially, those are the three things. One, were you the driver? Not hard to prove. Number two, what was your level at the time of the test? There's going to be chemical analysis from a toxicologist that we have in the police reports that will tell us what the results were. And number three is, did the officer advise you correctly? Again, best defense to that is the actual videotape of the event or the police officer's report, or that you did not understand through no fault of your own because you had some sort of head injury. So that's what happens at a DMV hearing. They don't last very long. They're not very informative. It's a very, very low burden. And that's why I generally will only have a client come and testify if the defense is that the person was not the driver on the day of the event. I hope that helps.